Welcome back to A Little Privacy Please. I'm Julie Rubash, General Counsel and Chief Privacy Officer at SourcePoint by Dodomi. This is my weekly series covering what matters most in data privacy. This week, Illinois signed a new age signal law targeting social platforms, and California raised the price of registering as a data broker. Let's start in Illinois. Illinois' governor has signed HB 5511, the Children's Online Social Media Safety Act. It mandates an age signal framework running from app stores, device manufacturers, and OS providers to social media platform operators and imposes new design and conduct obligations on those platforms. The act takes effect January 1st, 2028. Device manufacturers, OS providers, and app stores have to build the age declaration and signal interface by that date, and platform operators have until July 1st, 2028 to start requesting and acting on the signal. Enforcement runs exclusively through the Illinois Attorney General, with penalties up to $50,000 per violation. Here's what makes Illinois genuinely distinctive. Among the 6 states with age signal laws, Illinois, California, Louisiana, Utah, Texas, and Alabama, Illinois is the only one that limits who has to receive and act on the signal to social media type covered platforms. Every other state casts a much wider net. For example, California obligates any OS accessible app or developer to request the signal, and Louisiana obligates any app distributed through a covered app store. Even though the Illinois is narrower than most other states, though, a covered platform may be broader than what you would typically think of as a social media platform. So don't stop listening just because you don't typically put your company in that category. Under the Illinois law, a covered platform has to be intended to connect and allow a user to socially interact and let the user do at least one of three things: build a public or semi-public profile, populate a public list of connections, or create or post content viewable by other users, like message boards, chat rooms, that kind of thing. A general website or app that doesn't do any of those, like a pure content app, wouldn't meet the definition. But if you add a public profile or comment section, you might suddenly be in scope. So although the law is still far narrower than the catch-all scope of the other 5 state laws, the law is likely broader than its title implies. Once a platform is in scope, it has to request the age signal, treat a positive minor signal as authoritative, and apply a full set of default protections to minor users. The takeaway: Illinois' platform test is more expansive than the social media label suggests, so don't assume you're out of scope just because you wouldn't describe your product that way. But if you have no profile, connection, or content sharing features at all, you're likely outside the law entirely, unlike the broader scope of most other state age assurance laws, which generally reach any app regardless of whether it has social features. Now let's turn to California and the rising cost of being a registered data broker. At its August 2026 board meeting, the California Privacy Protection Agency approved an increase to the annual data broker registration fee from $6,000 to $9,500, effective for the 2027 registration period. The agency's reasoning centers on the cost of running the Delete Act infrastructure, particularly maintaining the Delete Request and Opt-out platform, or DROP, which brokers have to access every 45 days since August 1st of this year. California's fee was already more than double and is now more than triple the fee charged under any other state data broker law with a fixed fee. New Jersey is the exception. Its fee, taking effect in March 2027, is tiered by volume, ranging from $5,000 for brokers selling fewer than 100,000 consumers' data, up to $1.5 million for brokers selling data on more than 4.5 million consumers. So California isn't the most expensive registration in every scenario, but it is the most expensive flat fee by a wide margin. In fairness, though, it is still the only state with a centralized deletion mechanism actually operating today. Connecticut has enacted something similar, but hasn't implemented it yet. So we'll see if Connecticut raises its fees once those operating costs kick in. The takeaway: if you're a registered broker or on the fence about whether you qualify, it's worth factoring the new cost into your 2027 compliance budget and rechecking whether your data flows still put you in the data broker territory now that the price of staying registered has gone up again. Just don't let the higher fee tempt you into skipping registration altogether. An unregistered broker faces a $200 per day penalty for failing to register, plus a separate $200 per request per day penalty for every deletion request that goes unprocessed because they're not on drop. And that second number stacks up far faster than the cost of registering ever would. So, in summary for this week, Illinois joined the growing list of states with age signal laws, but with a narrower scope, and California raised the price of staying registered as a data broker. You can find more on both stories in this week's newsletter, A Little Privacy Please. I'm Julie Rubash. Thanks for joining me, and I'll see you next week. Until then, go enjoy a little privacy, please.